morning's presentation concentrates on the new Evidence Act, although its official title is the Evidence Act 2008. It did not come into operation, as I'm sure you're all aware, until the 1st of January of this year. You're probably also well aware that it was, or it is I should say, based upon the Commonwealth Uniform Evidence Act, and that of course goes back well over a decade. The Commonwealth Act was clearly introduced in an attempt to have uniform laws of evidence throughout Australia, and can I just say that is a view that I think needs to very quickly be concluded. The other thing, of course, is that evidence is the very basic building block of every case that you're involved in. It doesn't matter whether you're doing a civil case or a criminal case. The prosecution or the cause of action, it's great to talk about it in a theoretical sense, but if you don't have the evidence, then you're never going to get anywhere in the first place. So it really is a very important area, and I'm very glad that we on this list are prepared and have come along to talk to you about the Evidence Act. I think it's terribly, terribly important. Now, you're going to hear this morning from two experienced practitioners. The first you will hear from is Steve Milesi, and then you'll hear from Michael Pena-Rees. Steve, I should say, was admitted to practice in 2003. He signed the bar roll in May 2006. He may sound like he's a relative newcomer to the law, but he actually brings with him a much greater experience than those basic facts indicate. Before coming to the bar, he was a senior solicitor at the State Director of Public Prosecution's Office, and before that he did his articles at Cause Chambers Westgarth. But going back even further than that, and please forgive me, Steve, he had a career of some 17 years with the Victoria Police. He was a detective involved in investigating and preparing complex criminal matters, so you can see that he well has an understanding from a prosecution point of view over many years of the need for, firstly, evidence and secondly, admissible evidence. And he was also a police prosecutor during that period of time that he was in the police force. So again, he has much experience in relation to the practicalities and the application of evidence. He will address you on the new Evidence Act, its transition, relevance and hearsay. Steve, if I could ask you to...
Thanks, Brind. Thanks everyone for coming along. With any criminal prosecution, whether you're prosecuting or defending, we all have to work with the starting presumption, and that is one of innocence. And I'm sure none of you are under any illusion that defending a case gets a big advantage when the circumstances of the case enable the defence to put forward some alternative version of the events to the prosecution. Now that isn't always the case. Some cases it's simply a matter where the prosecution is put to their proofs. But as lawyers taking initial instructions and making an assessment of a case, whether you're defending or prosecuting, and I know in the audience here today we've got a good mix of people from both sides and from different areas of criminal law. But when you're preparing and assessing a case, you have to look at the case firstly to see if there's any evidence supporting the charges, and then how that will fit into any alternative versions. And you have to do this whether you're on either side of the fence. To do this properly, it becomes imperative to have a good working knowledge of evidence law. Admissibility of evidence is the primary tool that we have to use in assessing material in a brief. And I say that particularly in defending a criminal case, the application of evidence has two elements. Firstly, there's whether the prosecution will get their evidence in to prove the elements of the offence, and secondly, there's whether the defence can present or get from prosecution witnesses any evidence that will compel doubt. And my view is that it's very daunting stuff. In fact, I've been in trials opposed to barristers who are still trying to make the old rules work. There was one case I had earlier this year where I was prosecuting, and one of the key witnesses, I was leading him through his evidence in chief, and he just, for the life of him, would not give me the bit of golden evidence that I was looking for. It had slipped his mind, or he hadn't reviewed his statement well enough. We'd gone through it all before, but for whatever reason I couldn't get it out of him. So I made an application to cross-examine him on the basis that he was an unfavourable witness, and some of you may be familiar with those provisions. I'm not going to go into them now, but I was lucky enough to get the judge to accept my line of argument, and the judge thought it was unfavourable, that he couldn't remember this, so I cross-examined it in. And it got in on the basis that, well, I can't remember that happening, but I definitely said it to whoever it was he'd said it to. He'd said this key element. And then the judge and I agreed that, okay, it's now been cross-examined in, it's evidence, so it goes to the truth of what was said. And I'll get to that in due course, because that's one of the key elements of the changes to the hearsay law. And it was at that stage that my opponent just stood up and said, that cannot be right. The common law can never stand for that. To which the judge quickly shut him down. But that's the view that some people are still taking. But we have to, and the fact that you're here listening to this presentation is probably indicative that you want to take that next step. And all I say is that it might seem daunting, but cut yourselves a little bit of slack. There's quite a bit here to take on, and anything that you learn, don't give up, and we'll keep moving on with it. Because when I say it's substantial, and I see in the audience Glenn Barr, I remember when this stuff first came in, he quoted something to me, and it stuck with me, and I'm going to use it because when you look at what we do as lawyers, there's really three areas of knowledge that we all have to come to terms with. The first of those is substantive law, and that would be whether it's criminal, family, contract law, whatever it is you practice. The second is procedure, and for those, well, I'm sure you're all aware of the changes that have come in with the Criminal Procedure Act, but we've also got, in conjunction with that, a major change in the third area of law, and that is evidence. So with two of those three major areas of knowledge that as criminal lawyers we have to have our heads around, with two of those changing in 1 year, I think it's enough for any of us to think this is pretty overwhelming and to feel a little bit daunted by it. But as I said, cut yourselves a little bit of slack, learn what you can, pick it up along the way, don't give up, and it will all make sense in the wash. So one of the first areas specifically to do with the Evidence Act, the new Evidence Act, I say new, it is called the Evidence Act 2008, and as Brind indicated, it started the 1st of January this year. But it's called the new Evidence Act, or commonly the Uniform Evidence Act, and the title there comes from its main purpose, and that is to provide uniform evidence law with New South Wales and the Commonwealth. But when does it actually start? And if you've got a case before the court, does it apply, and do those rules apply, and how does it all happen? It can be a bit confusing, and when you've got such a broad area of change, sometimes it just gets annoying having to go back and look up every little thing to see when it all started. So I've included in that handout a very brief list of the changes and the transitional provisions. Now, there's really the first two clauses. It was introduced by the State Law Amendment Evidence Consequential Provisions Act, and it inserted it into the Evidence Act as Schedule 2. The first clause indicates clearly enough the commencement date, which is the 1st of January this year, and the second one refers to all hearings conducted on or after that date, or hearings within, let me start that again. All proceedings commenced on or after that date, or all hearings that are part of a proceeding where the hearing is commenced on or after that date. So what that means, in effect, is if your matter didn't start until this year, clearly the Uniform Evidence Act applies. If it's a matter that started last year, if it's a separate hearing in that, then the Act applies. If it's a hearing that's been adjourned, so you might have had a committal where part of it started last year, there was a witness unavailable. Although we're getting 10 months down the track now, this is unlikely, but this is what might happen. There's a distinction drawn between hearings in a proceeding. So if you've got committal, bail application, trial, they're all separate hearings. So it doesn't matter that one of those was heard last year. If one of them commences this year, the New Evidence Act applies. You'll see on that list there's a number of other clauses, 3 through to 16, and they relate to much more specific areas. And they're there for your reference, and hopefully you'll never have to go to that detail of referring to them. But there's some things in there that just might come along, and it's worth having a quick flick through it and just being mindful that it's there, because you'll have things like, if you look at Clause 5, it's about the exclusion of visual identification evidence and exclusion of evidence of identification by pictures. And in the Act, that's a bit of a significant area, because there's changes to the procedures police have to follow in obtaining that evidence. But you'll see that the new law doesn't apply to identifications that occurred before 1st of January. So your proceeding might have commenced this year, but if the identification by a witness who picked someone out of a photo board, for example, happened last year, then that provision doesn't apply. The rest of those, I won't go through them individually, but you'll see that they're worth having there just as a reference point. One of the key areas of evidence is clearly enough relevance. Now, it hasn't changed significantly with the Act, but I'll just take you through where it resides in the Act and give you a bit of an indication of how it would operate. So the test for relevance is contained in section 55, and it's not a new concept. Chief Justice Barwick in 1970 in the Wilson case said the fundamental rule governing the admissibility of evidence is that it be relevant. In every instance, the proffered evidence must ultimately be brought to that touchstone, and that hasn't changed. Section 56 of the New Evidence Act says that evidence which is relevant is generally admissible, and evidence which is irrelevant is inadmissible, clearly enough. The key element of Section 55, though, is that evidence is relevant if it is evidence which, if accepted, could rationally affect the assessment of the probability of a fact in issue in the proceedings. So the first step is in determining relevance is that it is fundamentally important to identify what are the issues in the trial. And that means identifying the elements of the offence alleged by the prosecution, the elements of any mode of complicity relied on by the prosecution, and the elements of any defence open to the defence. Now, anyone who's been in the Directions Court and been required to file a prosecution opening or a defence response will already know that the judges over there, the Chief Judge, Judge Hannon, Judge Chettle, are really coming down on this. If it's the old style, simple response or opening, they're coming down on it. They want to know what the elements are, what is going on, how complicity is relied on, and what defences the defence is saying are open. So this is where this comes from. There's another section to admissibility in section 55, and that is subsection 2, where evidence can also be relevant if it relates to the credibility of a witness, the admissibility of other evidence, or a failure to adduce evidence. That's straightforward enough. So relevance is assessed on the basis that the evidence in question will be accepted by the trier of fact, and then it's assessed as to whether it could rationally affect the assessment of the probability of the fact in issue. Now, that requires only a minimal connection between the evidence and the fact in issue. It's whether the fact in issue is made more likely or less likely by the evidence, however slightly, and that's where that assessment of relevance comes from. An example of how this would be applied is in Smith's case, which I think I've put the reference to in the handout, and it was an armed robbery case where the armed robbers were captured on security footage, and the prosecution in that case sought to rely on a police officer who'd had previous dealings with one of the accused, who said that he recognised from those security camera photos the person that he'd previously arrested. It was held that because that witness's assertion of identity was founded on material that was no different from the material available to the jury from its own observation, it could not rationally affect their assessment. And on that basis it was excluded as being irrelevant. The court in that case said that their assessment would not be assisted nor hindered, knowing that some other person had or had not arrived at that conclusion. And that's fairly... It makes sense. It's fairly logical, and it's perhaps a change away from the old relevance laws, which were a bit more based on legal relevance or sufficient relevance, to one of being a logical relevance. That's not to say that this notion of legal relevance is completely out the window, because Section 55 has to be read in conjunction with Section 135, which is a general discretion to exclude evidence. And the court in that case, under Section 135, can refuse to admit evidence if its probative value is substantially outweighed by the danger that the evidence might be unfairly prejudicial to a party, or be misleading or confusing, or cause or result in undue waste of time. Now that seems a little bit similar to the old probative value versus prejudicial effect argument, but it's probably a higher onus, and it puts it on the party seeking to exclude the evidence, and it's fairly considerable because the party has to demonstrate that the probative value is substantially outweighed by the danger of prejudicial effect, and that prejudicial effect has to be unfair. I know we're moving through this fairly quickly and it's a lot to cover. I'll move on to hearsay evidence, and at the end I'll try to stay within. We'll finish at 8. I think we're finishing at 8 o'clock for a coffee and before Michael presents his topic. But at the end I'm happy to take questions. There'll be 10 or 15 minutes for us to do that, and certainly while I'm not explaining this in any great level of detail, and I don't pretend to be, I hope that there's something you can all take out of it, and if there's any questions at the end I'm happy to answer those. As to hearsay, I'm sure that we've all got a pretty fair understanding of what hearsay is. The old sub-Romanian rules where statements being said out of court, usually by someone other than the witness, and it's being relied on as going to the truth of what was said, usually excluded on that basis. If it's being relied on solely for the fact that it was said, and this comes out of sub-Romanian, it usually wasn't considered to be hearsay, although we'll all know that under the old legislation, or before the New Evidence Act came in, it was forever litigated that balance between how it can be relied on as just being said and the prejudicial effect it has if it goes before the jury, and jury directions about you can only use it for this purpose. It was one of those areas that was just, it never sat comfortably with a lot of lawyers. And things have changed significantly in that regard, because Section 60 of the Evidence Act states that if evidence is admitted for a non-hearsay purpose, it becomes admissible for all purposes, including a hearsay purpose. Now, if you take anything out of this seminar this morning, that's probably the one point that you need to get your head around. Whether something goes in under one of the other rules in the Evidence Act, such as credibility or something along those lines, once it's in, it goes into the truth of what's said. Just an example of one of the significant implications of how this could be affected, and whether you're preparing prosecution or defence cases, the consideration of what people have said to doctors, or what people have said to police when police have shown up at the scene of crimes. Doctors and police are notorious for taking notes, and they take notes verbatim of what is said. And it's those things, whether those go in as a matter of credit because it's been suggested that someone's fabricated their evidence, or whether those things go in as part of, if it's a doctor, for example, as part of the reason how that doctor has formed his opinion or the basis for him forming his opinion, it goes in for those purposes. But once it goes in, it goes in for the truth of what's said. So if you've got the accused person saying, I did not do it, I was attacked first, or you've got a victim saying something completely consistent with what they're saying in evidence, I cannot overemphasise the importance that will occur in contested hearings of that repetition of either a consistent denial of an offence or a consistent version by a victim of what's happened to them. And this is the area where this section 60 has the most impact, because it goes into the truth of it. So once it's there, it can be put in some cases in writing, so the notes might be tendered, or a previous statement that's been prepared might be tendered, and it's there before the jury or before the magistrate if it's in the magistrate's court. Now, dealing with hearsay specifically, there's two general categories of exception to the hearsay rule. And there's section 65, where the maker is unavailable, and section 66, where the maker is available. Now, to fit into either of those exceptions, it has to be first-hand hearsay, and a witness gives first-hand hearsay of a previous representation. And I hope you all understand what a previous representation is. It's basically someone saying something that they haven't, they've perceived it, but it's been said or done or presented to them by someone else. So, a person gives first-hand hearsay evidence of a previous representation of a witness. If the witness gives evidence that they saw, heard, or otherwise perceived that representation being made. And the fact that is asserted by the maker, so this is not the witness that's giving the evidence, this is the person who made the assertion. If the facts asserted by that maker were seen or otherwise perceived by that maker, so in other words, John told me that he saw Tim commit an armed robbery, right? So you've got the maker is John, and he's telling you something that he perceived himself. He saw Tim commit an armed robbery. He's giving it, John is then telling the witness about it. The witness can give that evidence as first-hand hearsay, if it fits within one of the exceptions in the Evidence Act. Alternatively, if he said, John told me that Tim told me that he committed an armed robbery, you've got second-hand hearsay. It's clearly not first-hand, because John, who's the maker of the representation, did not perceive what actually happened. All he's saying is what he was told. So section 65 is an exception to the hearsay rule for first-hand hearsay where the representor is unavailable. And it's set out in the dictionary at Schedule 4 to the Evidence Act what the definition of an unavailable witness is. And basically it's where a witness has died, where they're not competent to give evidence, where it would be unlawful for them to give evidence, where all reasonable steps have been taken to find the person and the person can't be found. And all of these are alternatives, they're not additions, so any of these will fulfil that criteria. Or where all reasonable steps have been taken to compel the person but without success. Just by way of a couple of examples of rulings from other jurisdictions, and the great thing about the Uniform Evidence Law is clearly that it comes to us with a great body of authority already in New South Wales and in the Commonwealth jurisdiction. We're building up our own body of authority, but that will take an amount of time, but clearly getting your head around the New South Wales and federal cases is a great start. And in Setesky it was held that where a witness refused to give evidence at all, although subpoenaed, they were considered to be an unavailable witness. Now that itself could have some far-reaching implications because in cases where you've got an alleged co-offender who makes an inculpatory record of interview, it's a previous statement made by that person. The recording's there, there's a police informant who can give evidence, this person told me this. If they refuse to give evidence, the implications are that that can be relied on, and it might say, yes, I went and committed this armed robbery with that accused. In Tabor and Steinman, there was a former co-accused who'd given evidence at an earlier trial but then refused to give evidence. He was also considered to be unavailable, and a transcript of his evidence could be tendered. While it might seem to be expansive, there are limits on it. A witness who could not recall as a result of sustaining brain damage was not considered to be unavailable. That's in the Queen and Brown, Barwick and Brown. And a witness who claimed not to remember an incident, even where that was suspected of being a false claim, was considered to be not available, and that's Tan and the Queen. Now, there's circumstances where, when the maker of the representation is unavailable, there are a number of circumstances that, a number of criteria that must be met for evidence to be admitted. These are in section 65(2), and basically first-hand hearsay is admissible if the maker is unavailable and they had a duty or to make that representation or that type of representation, or where the maker made the representation during or shortly after the asserted fact's occurrence, and it's likely in the circumstances not to be a fabrication. Now that criteria is a little bit like the old res gesta, and that's how it's been considered. And Williams, I think, is the authority where that freshness in the mind is considered. And it was held that it must be made spontaneously during or under the proximate pressure of the occurrence of the asserted fact. The next criteria is where it's made in circumstances that make it highly probable that the representation is reliable. And the final one is at the time the maker made the representation, he made it against his interest or it's likely to be reliable. Now the discussion or the reference to reliable there and the taking into account of the circumstances was also dealt with in Williams' case, and it's a matter of taking into account all of the circumstances, including the making of the circumstances in which the statement was made, consistency with other evidence in the case, and evidence of what the maker of the representation has said on other occasions. Beyond those criteria, a further exception to the hearsay exclusionary rule is section 65(3), and that provides where evidence of a witness given in an earlier proceeding is admissible if that witness is unavailable. Now this again is a significant one for all of us practising in criminal law, because it adds an importance to committal hearings that they probably never held before, and a lot of people, I know incorrectly, but a lot of people held the view that committals were a bit of a dry run, or it's a bit hard to stuff up a committal. As long as you don't put all of your instructions, you'll go all right with it. But if you think of the circumstances that can happen in accordance with this provision, if a witness comes along, gives their evidence at committal, and they're cross-examined, they then become unavailable for whatever reason, that evidence goes in, and it goes in for the truth of it. If they weren't properly cross-examined, then that can have a significant impact down the track. So again, it's an area that is very important and needs to be borne in mind when preparing cases right from the beginning. All right, now there's also section 65(8) extends the exception to the hearsay rule where it's called by the defence, where a witness is unavailable. Again, a very important area to be aware of. it doesn't have all of those criteria that I said in 65.2 about, which are included in that handout. The reference to it being under a duty to make the representation made shortly or after the asserted occurrence. But it needs to be taken into account that if this is relied on, then the other party, most usually the prosecution, can rely on section 65.9 and other evidence on the same topic could be admitted. And that's not limited to representations that were made by the same unavailable witness. The other main exception is section 66, and I won't go into any great detail about it, but it's where the representor is available and where a witness is available, evidence can be called of a previous statement of a witness if it were made when the events were fresh in the memory of the maker. Now this used to be limited to cases of sexual offences or where credibility was in issue, where you had an evidence of a first complaint or evidence of a prior consistent statement. But it's much broader than that now. But there is a significant limitation on the prosecution using it, and that is that it can't be used where a statement is or some other material is being prepared specifically for upcoming court proceedings. So a statement that's taken by the police intended to be used at a committal, one that's acknowledged and durated, is excluded by that. However, it's not excluded for the purposes of the defence. They do not have that same limitation. So I can't stress the importance, if you're acting for the defence, to consider getting proofs early on. When witnesses come in, get them to sign a statement. It could be relied on. It can be, and it's the circumstances where if that gets in, the witness may have given their evidence, and then the statement can be tendered. It might say exactly the same thing, but it cannot be underestimated the impact that can have on a jury, just to hear that repetition, to hear those consistent denials or that consistent evidence that puts forward an alternative to that person's guilt. Okay, it looks like we've just about got to the end. Now, hopefully what I haven't covered sufficiently is set out in that paper. Please take that away. Feel free to use it as you wish. I think that most of it's right. If it's wrong, please let me know. There are a number of more remote hearsay provisions that I think I've included at the end, and they refer to business documents and the like. Most of those haven't changed a lot from the old common law or the old Evidence Act, but clearly enough we have to be applying the new legislation, and if anything it probably makes it a bit more of a step-by-step process and a bit more logical. There's notice requirements in certain circumstances when seeking to rely on hearsay evidence. Those mostly apply when a witness is unavailable. So you've got section 65.2 and 3, so where the prosecution is seeking to rely on it under those sections, and where the defence seek to rely on it under section 65.8. Now, it's a significant omission that where a witness is available and you seek to rely on that hearsay evidence, there is no notice requirement. So there you have it in a nutshell. I hope that's been of some assistance, and as I indicated earlier, I'll be open to questions later. Thank you.
Thanks, Steve, very much. I think you'll all understand from that there's a lot of things we need to get on top of, but one of the things I think that does come out of that, particularly in relation to the hearsay evidence provisions, is that you're going to have to really think very seriously about what you do at a committal proceeding, and whether you seek to cross-examine a witness, because if you've had an opportunity to cross-examine the witness and you've not taken up that opportunity, then under 65(3), the evidence may very well get in and be very dangerous for your client simply because you didn't choose to cross-examine at the committal proceeding. So it is something we really all are going to have to consider very seriously.